Thank you. Please be seated. Good morning. We are here for oral argument in case CV190007, Montana Ranch versus Beaith. And these proceedings are being video and audio recorded as well as live streamed. So we ask counsel to please identify yourselves and your clients at the beginning of your arguments. Each side will have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of time for rebuttal if so desired. Also, we have read the briefs and we have conferenced the case. Counsel, you may proceed.
Thank you. I'm Richard Mack. I represent the appellates, the Beaith. This case involves the selective enforcement of CC&Rs for subdivision in violation of the Fair Housing Act. Brief, important facts I want to run through. The Beaiths bought this property in 1999. They lived there for 10 years. They leased it out to a series of tenants without incident after that. 2016, they leased to Valor Behavioral Health. Valor is a company that provides outpatient treatment services for recovering alcoholics. The treatment occurs about 10 miles away in their office building, medical office building. However, as part of the program, the residents or the patients were living in houses throughout the valley, including the Beaith's house here. The gentleman that lived there did what we all do in our house. They slept, they ate, they bathed, they read, they watched television. In fact, the HOA admits that this was a typical residential usage. It wasn't commercial, it was a residential usage.
Are you saying that there was no aspect of the rehabilitation services that were being carried out at the residence?
That's correct. They were all on the medical facility in Scottsdale, down on Scottsdale Road.
There aren't follow-up meetings or no discussions at all at the house?
In terms of the treatment program, that is correct. They were living there with other recovering alcoholics, but in terms of the treatment, no, it was all done in the office building in Scottsdale. There was never a complaint. The the HOA maintained a violation log where they would canvass the neighborhood and identify properties that were in violation of the CC&Rs. These gentlemen lived in the house for 2 years, and there's not a single violation relative to their occupancy for the entire time they were there. Yet they were sued, the Beaiths were sued, and the HOA demanded that they remove Valor from the premises. The lawsuit's based primarily on 2 points, and we disagree as to one of them in terms of what was pled, but the short answer is this. There was a parking contention, and there was a commercial enterprise contention. The parking is where we disagree because it was the van, a bus or an RV or so on and so forth, but that's really of no moment for our purposes. The jury already made the decision, but I just want to briefly talk about what happened. The CC&Rs say automobiles must be parked in the garage. That was never enforced. Many other homeowners in the subdivision were allowed to park their automobiles in the driveway, provided they were driven daily. In fact, there was a written policy by the HOA allowing this parking. So the enforcement here against Valor and the Beaiths was not only selective, but it was inconsistent with what everybody else in the subdivision was allowed to do and inconsistent with the policies. The second piece, or second general idea, is this commercial enterprise prohibition. Again, it had never been enforced before. That's undisputed. At trial, at a minimum, there were other businesses there, including a real estate brokerage firm, an embroidery shop, an embroidery service, and an Airbnb. The HOA took no action against any of them. Again, enforcement was reserved for...
Airbnb is running a business?
The language in the CC&Rs is very broad. It says no commercial enterprise. So arguably, yes, it comes within that purview. And the court in its minute entry addresses that as being an issue that it was concerned with, but then he went the other way in his decision.
Is there anything in the CCNRs or policies or something in the record that ties the limitation or restriction on commercial enterprises to the nature or character or conduct of the?
No, ma'am, it's
Commercial
very
enterprise.
generic. That just says, no, thou shalt not conduct a commercial enterprise,
Okay.
is effectively what it says. And there's well, back to it. These guys lived there. They weren't running a business. They lived there. The HOA conceded it was typical residential usage. And I cited a South Carolina case, it's Palmetto, it's 400 Southeast 2nd, 484, that addresses this very issue. And it says, it goes through a good analysis, and it effectively says, look, a sober living house, even if there's a manager there doing some paperwork, is still a residential usage. That does not convert to a commercial enterprise, which might run afoul of CCNRs. 3 more points I want to talk about the facts. The HOA demanded a copy of the lease here, lease between Valor and the Beath. They've never done that before with the Beaths or any other occupants in the subdivision. The request violated Arizona statutes. They can't do that. They're property managers, so their agent knew at the time of that restriction, and the agent told the Beath that the request was, quote, illegal. Before the suit, the HOA was advised on 3 separate.
How does that relate to whether, I mean, to your damages for either they were running a business there or they were not, a prohibited business?
No, it relates to one more prong in the sort of culmination of events that they were treating Valor differently because they didn't want them in the neighborhood. Never done it before, did it here, violated by statute. Their property manager knew it was improper. That's the point I'm trying to make. Before suit was filed, the HOA was advised 3 times that their factual assertions they were making were wrong. Valor didn't have a bus or an RV. There was not a commercial enterprise going there. And they were also advised that these are recovering alcoholics protected by the Fair Housing Act. The HOA did nothing to investigate that issue. They didn't follow up. They didn't ask questions. And in fact, at trial, they admitted they had no evidence to refute the factual assertions, the factual information shared with them, yet they proceeded anyway.
Right, so you're saying the trial court just got it completely wrong by concluding that Valor is running a business?
Yes. Yes, absolutely. And regardless, it's protected by the Fair Housing Act, yes.
Those are maybe different questions.
Fair Housing Act trumps any CCNR enforcement, which is regardless. If you're
If you have a
enforcing,
CCNR, and let's say they're not allowing any other businesses anywhere in the neighborhood, they nevertheless have to allow a business in that involves providing some housing?
a business, no. But in the interpretation and enforcement of those CCNRs, they cannot do it in a way that makes housing more difficult or unavailable to persons with a handicap.
But if the Superior Court finds that Valor is essentially running a business, if they disagree with your assessment that nothing's happening other than people are eating, sleeping, and going out for walks or whatever, if there is some evidence, let's say that there's some group therapy going on, I'm making up facts, but would the homeowners association not be entitled to say, no, that's a business?
No, sir. And let me back up. First of all, that's not our record.
But I'm assuming this is the record, that we're actually having meetings on site. We're inviting other people to come in and have meetings on site with people there. The homeowner association couldn't say that that's prohibited.
If it violates the Fair Housing Act, they cannot. And
How
simple
does it violate
example.
the Fair Housing Act if these other things are happening there is different than just providing housing is where I'm trying to go with this. And if the court is below found that other things are happening besides someone just living there, what are we to do with that finding?
There weren't, number one, look at the Palmetto decision. Number 2, look at the admissions made by the HOA that says it was a typical residential usage, and explore the record that is inconsistent with what happened. And the other piece, Your Honor, many CCNRs say only Caucasians can live in a subdivision. I mean, if you go back to 1950s, that's what they say. Those aren't enforceable, so they can't be enforced in a way that violates fair housing. That's the position. With the, one more point, the reasonable accommodation, the Beath requested a reasonable accommodation to allow Valor to continue to live there. And actually, let me back up and hit one more point. The court can't make factual determinations inconsistent with what the jury said in any event. So to put a fine point on what you're asking me, if you look at the cases we cited, the Curtis case, the U.S. Supreme Court case, the Beacon Theaters case, another U.S. Supreme Court case, the LeBlanc case, very similar to ours procedurally, those cases stand for the proposition very clearly that a trial court, in fashioning its relief, may not disregard jury findings on common issues of fact. And that's what Judge Below did. So that's the real answer to your question that I didn't deal with. Reasonable accommodation. The Beast requested a reasonable accommodation. It would have been as simple as allowing, maybe investigating first, asking some questions, but allowing these folks to continue their residential usage and to continue to park their van, not a bus, but a van in the driveway.
I understand the van, if there's a question about whether it's a bus or it's an extremely large van. But reasonable accommodation, if there's a prohibition against running a business, you can ask for a reasonable accommodation to say you can run a business? What's the accommodation you're requesting?
The accommodation would be allowing these gentlemen to live there as a typical residential usage, not run a business.
Why is that an accommodation?
Well, because in my position, it's not necessary, but according to them, they're claiming it was a commercial enterprise, should have explored what was actually going on and then made a decision. Instead, they admittedly received the request for the accommodation, ignored it. Didn't ask questions, didn't have the courtesy of a response, just ignored it.
And that seems to be acknowledging we're doing something that's prohibited by the CC&Rs. We're running a business, we'd like an accommodation because these are people who are protected.
Yeah, you're darned if you do and darned if you don't. But yeah, because there was the push to remove these gentlemen in violation of the Fair Housing Act, then it's embedded in the statute in the cases interpreting the federal Fair Housing Law. Ask for a reasonable accommodation. Here's what we can do. We can adopt a policy that isn't going to affect anything. In fact, this occupancy didn't affect the residential neighborhood at all. It remained an upscale, beautiful neighborhood with no complaints. So a reasonable accommodation could have and should have included just what these gentlemen did. Live there peacefully, not causing problems, and parking their van in the driveway. So it was ignored. And I'll hit the legal stuff.
Was
Yes, ma'am.
there a definition for business purpose or commercial enterprise in the CC&Rs?
My memory is, Your Honor, it simply addresses there shall be no commercial enterprise. In terms of what that boils down to, no, there's not.
All right, proceed.
Our cases, Kennedy and Westwood, both stand for the proposition that you cannot enforce CC&Rs in a way that violates the Fair Housing Act. I think we can all agree on that. Pacific Shores, a Ninth Circuit case, says, among many others, recovering alcoholics under certain...
I'm still struggling with if it's not a business, then you're not enforcing the CC&R. And if there's a prohibition on doing business, then you're prohibiting businesses regardless of whether it's race or based on a handicap. It doesn't matter. You're just not allowing anybody to run a business.
Again, the record provides otherwise, and the jury verdict, which the court is bound by, has a different conclusion than what Judge Corey said. And again, that's the United States Supreme Court decision.
Didn't the parties agree that the judge would address whether there was a violation of the CC&Rs?
I'll address that. Yes. Let me take that in turn. Declaratory relief claim is a judicial decision. Agreed. That's not a jury question. We all concede that. We agree with that then. We agree with that now. However, it's not done in a vacuum. When there are common issues of law and fact, the court, in its own separate decision, is bound by what the jury determines. If you look at that LeBlanc case, it's the exact same procedural posture. That's a Second Circuit case. And there, the trial court found no fair housing violation, just like here. The jury, however, did find a fair housing violation. The court entered a judgment consistent with its finding, and it was reversed on appeal. So that issue was resolved. And let me talk about that waiver argument just briefly. I've got about a half a dozen things I need to say. Number one, we asserted the fair housing claim and the right to a jury trial through the verdict. Number two, we resisted the court's attempt to bifurcate the case. The court wanted to hear the DEC action first, the Fair Housing Act, and the intentional interference claim to come later. We resisted that. And how we resisted that was, one of the reasons was saying, look, our defense to the DEC action, one of our defenses, is they cannot enforce this in a way that violates a Fair Housing Act. We pled the Fair Housing Act through the counterclaim. So they even cite the language. What we said then is exactly what we're saying now. The jury needs to weigh in on the Fair Housing Act as part of this, and there's no need to bifurcate. We didn't request jury interrogatories because this was not an advisory jury. This was a mandatory jury, so interrogatories don't matter. We briefed the judge invading the province of the jury post-verdict after we had notice. We didn't know he was going to do that until the minute entry came when the jury verdict was coming down. And their waiver argument, let me address that. If you drill down and look at what the HOA is saying with respect to waiver, they cite three cases: Harrington, Hub, and Evans. Harrington and Hub deal with jury waivers in a written contract. Harrington and Hub are situations where parties, as part of a purchase and sale agreement, sign off and agree we're waiving our right to a jury. That's not our case. The other case is Evans. The Evans case deals with a situation where the plaintiff's counsel never requested a jury trial. The trial court confirmed, you can have a jury? No, I don't. And then later on appeal made an argument that you deprived my client of their jury rights. That's not our case either. Finally, factually, if you look at what they say that what we did with respect to the waiver, number one, we were dealing at the pretrial conference. We had about 15 motions in limine to argue. We were specifically at the time, if you look at the transcript of what they cite me, we were specifically at the time dealing with a motion in limine dealing with the intentional interference claim. The question was, is the complaint itself evidence of interference, and can we use it for that purpose? That was the issue. Judge made some comments about the DEC action, what he's going to do, and to put a fine point on it, not only read it in context, because it's motion in limine number one with intentional interference claim, not fair housing, intentional interference. But at the end of when I sat down, the judge says, let me hear from Mr. King if I could, please. Thank you. Mr. King says, thank you, Your Honor. Court, sure. Mr. King, so to be clear, we're talking about the intentional interference claim. The court, yes. Mr. King, okay. The court, motion in limine number one. Bless you. So anything that I said that even can be remotely construed as a waiver, which it wasn't, but they specifically put a fine point on it and says, we are talking about the intentional interference claim here, correct? The court said yes. I will like to reserve the rest of my time. Our position as to damages, the instruction on damages not being sufficient, successful party, reasonable fees are on the record, and I would like to reserve my last 2 minutes for rebuttal.
All right.
Good morning, Your Honors. Mike Wierzinski here with my law partner, Brad Jardine. We represent Montana Ranch HOA. Because time's short, I'm going to avoid the joke of going last right before lunch. But I want to pick up where counsel left off and talk about that procedural issue for a moment. Your Honors, respectfully, counsel's wrong when he says this came up very quickly at the end of a pretrial conference. This issue regarding how the case was going to be tried was brought up from the outset, from the joint report EIR 25 signed by both parties, suggesting that this was a case in which the declaratory matter would be decided by the court, period. It went on through an emergency conference in July of 2018, which was then with the new judge, newly assigned judge to this case, in which how is this case going to be tried? Because there was this declaratory judgment action that was going to be tried entirely to the court versus a FHA counterclaim that was going to be tried to the jury. The court had an involved discussion in there. It's cited, in our statement of the case, we provide you all the citations of how that went. I won't repeat it all here. That conversation continues on to 7/24, again, before the joint pretrial conference or the pretrial conference, in which the plaintiffs, I always want to say plaintiffs, I apologize, in which the trust, and the trust was the party, not the Beaths, in which the trust provided an opposition to bifurcation. I would, if you want to know the crux of what they were arguing, I would, at the relevant times, I would encourage you to look at that document. If there is any greater concession that their bifurcation, or the reason that they didn't want bifurcation, had nothing to do with the jury deciding the court's declaratory judgment matter and the facts surrounding the same, it's the reasoning. The only reason they gave there is, Judge, we're using the same facts to defend the matter you're going to hear as we are presenting the one the jury's going to hear. Just as you can in any other legal matter in Arizona and anywhere that I know of, you can waive a jury trial right. That's what happened here. They either waived it or they failed to timely object when it became adamantly clear when the judge said over and over and over, I'm deciding this deck action stuff. The jury's deciding this FHA stuff. It became crystal clear on 9/4/18 when the judge gave us his minute entry order on that before the jury, almost literally as the jurors were leaving the courtroom to go make their separate independent judgment. The trust decided how it wanted to try their case. The trust didn't sit by and fail to play a role and get sidetracked by this or sideswiped by this issue. They were part of this issue throughout. Everybody knew what was happening, including the brand new judge. Oh, you want me to hear the deck action case and act as a fact finder and act as a decision maker. No objection, no agreement, only acquiescence to that until it didn't go their way. Your Honors, by that time, it's far too late to interpose either an objection or say, wait a minute, we didn't waive or we didn't mean to waive anything. It had already happened. And to come back and say, well, look, Your Honor, we need now the government to bail us out. We made a mistake. We should not have allowed the case to be tried this way. Is simply, it's too late under Arizona law. So,
Could I have you address?
Sure.
Would you agree that maybe you don't agree, is the jury verdict inconsistent with the court's ruling in the deck? Ruling.
I don't, not trying to be smart, but I don't need to agree or disagree with you. Our trial judge said, no, it's not inconsistent. Because what the trial judge found is, look, the acts that violated the CC&R have nothing to do with the people in the house. It has to do with the fact, the sole facts, that one, the trust for economic reasons and economic reasons alone rented it to the highest paying bidder, a for-profit corporation, Valor, to run part of their for-profit business out of. Purely commercial. Purely commercial.
Are there not other commercial businesses in the neighborhood?
There are not any other purely commercial businesses. They're secondary at best to the primary basis for which the people.
Was there a real estate office, or they mentioned a seamstress?
There was.
Distinction?
I'm sorry. There was evidence of a real estate broker business for which Ms. Beaith testified that she heard from that neighbor, which was their next door neighbor, that he had a sign posted in her window. But in fact, there never was a sign posted in the window. I think the trier of fact, the judge, relative to our issues, the jury, relative to their issues, was free to view that and weigh that evidence appropriately. In terms of the Airbnb is what Airbnb is. The judge allowed them very minimal basis because of disclosure problems they had with all of that. And in terms of the seamstress, I don't think there was any conversation about, and certainly no proof that she didn't live there, that she only ran a commercial enterprise there. Here's the other salient fact, and I would suggest there's only a couple of facts you need to know in order to resolve this whole thing. One is, this is the only sole commercial enterprise run in that community that's expressly set up not to have commercial enterprises. The only one. Why isn't there evidence of some other maltreatment of some other sole corporate entity running a business in there? There were none, ever.
You were saying the jury
Sorry.
will do with it what they will, and the judge will
Sure.
do it. That seems to suggest they're considering the same evidence and reaching a different conclusion.
Well, to the extent that creates a problem, that was a problem created by plaintiffs waiving their right to have the jury decide contested issues of facts that they could have done under the Declaratory Judgment Act. We cited the statute.
So you're saying the result is inconsistent?
I don't think so, for the reasons the judge stated, that the act that violated the CC&Rs had nothing to do with who actually ended up occupying it. It had to do with the fact that somebody who is a resident there is not living in the house. They are renting it for profit to a for-profit corporation. This is not even a nonprofit trying to do something positive in the neighborhood. These are all people trying to make
Ask
money.
you, if there was a medical practice, and the medical practice leased a home, as occurred here, for the purpose of allowing traveling physicians to come in for a week at a time or a month at a time to work at the medical practice. So those physicians are residing in that home. All they are doing is residing in that home. It is a for-profit medical practice that is leasing the home. So would you say that that is running a commercial enterprise for the doctors to be able to reside there overnight in order to conduct their medical business on the medical facility outside of the residential neighborhood?
In direct answer to your hypothetical, Your Honor, I would say it is probably not a for-profit enterprise. I can make the argument that it is, but I think the better argument in this case is that hypothetical, with all due respect, comes nowhere to approximating what was going
Isn't
on
that
here.
exactly? We're talking about there's a for-profit hospital who hires doctors.
Sure.
And they need a place for the doctors to stay. They
Sure.
rent a house. They put the doctors in the house.
Sure. If the doctors were being drug tested as the people in the house were, if they were having group meetings as the people in the house were, if they were monitored 24/7.
Is that all happening in the house?
Yes, in the house. That's in the record.
The
It
group
was-
meetings are happening in the house.
Yes. Look at the advertisement they put out, that they put out. It's one of the admitted exhibits. I'm horrible with numbers, so I'm not remembering it, and I didn't write a note. But their own advertisement says, this is what we do in the house. 24/7 monitoring.
So I guess
That's
that's my fundamental question. If none of that is happening, then would the homeowners association be able to find a violation? If all they're doing is living there, the fact that it's a for-profit company that's making money, but they're just having people eat, drink, and sleep in the house, is that a violation of the CC&Rs?
As long as that for-profit company would let anybody else live there doing exactly the same thing, that's fine. But Valor wasn't doing that. I specifically asked the director of Valor when she testified, if I wanted to come and live in that house, you say there's no treatment there. If I wanted to come and pay rent to you to live in the house, could I do it if I wasn't in your program? She said, absolutely not. You have to be in the program. I got to pay for that program to be in that house because they're doing programs.
That goes to the hypothetical
Okay, I'm
proposal.
sorry.
If they're just
I
some
didn't-
doctors, if the doctors are all living there, the hospital's not going to rent it out to any other people. We got this house for some doctors that work in our hospital, but nothing's happening related to the practice.
Well, I think what you're defining, Your Honor, is there is a line. There's got to be a line somewhere. And we're trying to get to where the line is, but this case is so far beyond that line.
You're just saying there were things that were happening beyond eating, drinking.
Oh, most definitely, and that's exactly what the trial court found in his role as a fact finder. That just simply wasn't believable, particularly when we went through and said, well, wait a minute, even your own literature says you do all these things. Do you do those in there? And it's yes.
So who was doing the monitoring and the drug testing and all of that? Is
There-
the person living in the home also?
24/7, and that person arranges all the schedules, including meals, gives assignments, gives chores, takes care of the drug testing, tells them where they have to go, when they have to go there, arranges all the outings, arranges all the transportation. They're not allowed to have friends and family come in unless that person says so. It's a very rigorous, for all the understandable reasons, and I'm not condemning the practice. I'm saying that when you are exclusively running that as part of your for-profit commercial enterprise, You can't get away with saying, oh, these people are just living there like they were. Otherwise, if they were living there like anyone else, as evidenced in the record, as used by the judge in making his ruling, there were people in Montana Ranch who were recovering addicts, who were happily living there in their house and going and getting treatment in other places. Here's the hypothetical I would give you that I think rings true from the record in this case. If there were 5 people who rented a house to live in on their own accord and then went other places to get their treatment and caused no problems, we wouldn't be here. We would not be here.
How about a group home for developmentally disabled kids or teenagers or adults? Is that, if they're living there, would that violate the CCNRs? There's no treatment for them, but they obviously have to have someone staying there.
As a commercial enterprise or non-profit?
It's a commercial enterprise. They're making, somebody presumably makes money, some kind of profit, providing a service.
There's lots of non-profit organizations that provide addiction counseling, DDD.
So if this is a
things.
nonprofit that sets up the group home, you'd say that's not a violation, it's not running a business? I'm not getting the distinction here.
Oh, I think well, first off, let me try to answer a question because I'm being at least rude, I'm not trying to be impertinent though. I think that gets much closer to the line of saying you can't simply keep those people out because they have a disability. When you're talking about addictions, this gets into some finery of the nuancy parts of it. Merely having an addiction does not make you disabled in an FHA. There's several other things you have to be, all of which was contested and discussed.
Let's say we agree for purpose of argument that
Okay, fair enough.
they fit in the same category.
If they are in the same category as people who don't have those other requirements, then I would agree with this. If it's not for profit, if all they're doing is living in the house and getting the maintenance they have to have, well, if all they're doing is living in the house, then it'd be just like the addicts who live in our place already who are getting treatment elsewhere, who live there.
So what you're saying is
Unbothered.
that there's lodging and then there's lodging plus something else.
So in the case of a group home, so group home for developmentally disabled would typically also have a house mom, somebody who assigns chores, somebody who makes sure they get into and out of bed, into and out of the shower safely, so forth. Those extra services would change the character. such
The
that it's not
totality
permitted.
of the services they got at the house, in conjunction with the programming they were doing outside the house, pushes them over that line. They are a commercial enterprise conducting part of their commercial, not just lodging people like the airline pilots or like the medical workers. They are doing active services for what these people are paying at the house. And they're not doing one or two. They are not doing what we routinely do in our homes, as counsel said at trial, and now has told you here, that's not supported by the record. Yeah, and I don't want to belabor that, the record's there, I know you've all looked at it, and your clerks have looked at it, so I'm not going to bother you for that. I don't know whether, I did want to make another point relative to the waiver issues. Counsel brings up the federal court cases talking about the Seventh Amendment. Couple of points relative to that. First off, this case was tried in state court. The Seventh Amendment doesn't apply to the states, either by its own volition or through the 14th Amendment. I think it may be the last constitutional right that doesn't. I could not find, and I don't believe there is, because counsel didn't find, a case similar to ours in which any Arizona court has said, even if you waive or even if you fail to object, the court has to sua sponte, step in and accept the jury's ruling in a DEC action case. I would argue our very progressive DEC action statutory regime and rules provide that the court is supposed to make determinations in a DEC action, and it's supposed to resolve issues if requested, factual issues if requested by virtue of special interrogatories. I think we cited a case in our brief that stood for the proposition that when the trial court judge, it's called Mill Alley Partners, I believe, when the judge waited for the jury to make the determination and then made his determination on the jury's finding of a matter of law in his deck action, the court erred. He's supposed to make it independently. He can do it with the assistance of him. That was not an FHA case, and I don't want to at all mislead you, but it's the closest approximation to this that I could find. I don't know if you want me to address any other further questions or issues, Your Honors.
I'm just,
Sure.
the only cases that are, and I don't remember specifically which ones, but the only ones that are coming to mind in the FHA context are the homes for developmentally disabled children or adults. And it seemed like they found that homeowners associations cannot restrict having those in the neighborhood. I'm wondering what the distinction, and I may just not be remembering enough about those, but is there something different about those cases? Or does it simply turn on whether there's a business being run, meaning something else is happening other than simply living there?
I don't know whether we're mentally comparing the same cases that neither one of us remembers the name of, but the ones that I'm thinking of had to do with city codes and specific city code restrictions where the government, not the collection of homeowners who bought the property, the private property, with specific intents and specific contractual agreements. I can't think of an HOA case that's involved in I think it's fundamentally different when you have the government telling the property owners what they can and can't do on their property versus the property owners in their collective through their elected HOA board saying, hey, this is what we all agreed to, these are the rules we have.
There's a difference, so the government can't violate the FHA, but homeowners associations can get together and agree to violate? Not sure I'm following.
No, I think a homeowners group can make, no, I'm not trying to say the homeowners have more
But you're
latitude to
suggesting the
violate any
cases are
law.
distinguishable because they involve
Well,
the
I think-
city trying to stop something as opposed to homeowners.
I think there's more scrutiny when the government is imposing those on a citywide basis, on a code-wide basis versus a private collective agreeing this is what it is with no, and this case was not tried as a purposeful discrimination case. It was, can't remember which one's de jure and which one's not, but this was an implied discrimination effort. And the only evidence relative to whether there was any knowledge that any of these people actually had a disability as opposed to were people who were addicted to substances, programming there and programming elsewhere. That was absent. A number of other things that I don't want to utilize my final 45 seconds prattling on about stuff you guys haven't asked me about. So let me do this instead. Is there anything else I can answer for you before I sit down?
No, thank you, counsel.
Thank you.
Thank you. This case was tried as an intentional discrimination case. The jury was specifically instructed as to intentional discrimination. That's point one.
You only have
I
2
know.
minutes, and I just want to clarify. You said there was nothing else going on there other than persons eating, sleeping, resting, like anyone else does. Is it true that there was more going on, that there was monitoring, drug testing, and other services?
There was monitoring and drug testing, and there wasn't a group session, there was a meditation session that was
What is that?
voluntary. You could meditate with your fellow inhabitants if
What,
you wanted to.
sit together and do what?
I don't know what they did, Your Honor, I'm sorry.
But
I don't-
but related to their common interest in recovery, or related
Sure.
to something else?
No, I believed it to center themselves and get ready to go face the day.
And that was at a set time every day?
The record does not address that. I don't know.
You said that was a voluntary?
It was
session?
voluntary. If you look at the complaint, it's addressed in there. It was one of the amenities they offer, much like a television.
Okay.
It's
Was
listed.
the monitoring voluntary?
the monitoring, much like the other group homes, to answer the questions, the cases on point are Kennedy and Westwood. And in both of those cases, there were folks in the home monitoring. One was a group home. Westwood was a group home. Kennedy was a disabled 26-year-old gentleman.
And
So
in this home, was there a schedule for different chores that needed to be done and someone also monitoring compliance?
they got up and went to the facility at 8 o'clock every day, so shooing them out the door like you would, yes. But there was a chore checklist, I believe, is what the testimony was, that the people had to do as part of living there.
All right,
A few more points.
I'll give you 1 extra minute.
Thank you, thank you, thank you. We tried it as intentional discrimination. The cases are at page 15 of our brief, and they both do involve groups, homes, and disabled, or fundamentally disabled. Westwood, it's 155 Arizona 229. That's the seminal decision in Arizona. And then Kennedy versus Prescott 204 Arizona 91. To answer your question directly, Your Honor, yes, the jury verdict and the court's findings were inconsistent. The court found something other than rather than fair housing discrimination being the basis for the position. So they were diametrically opposed, still bound by what the court said. And in terms of what else was going on there, other businesses, the court in its ruling, if you look at that September 4th minute entry, the court acknowledges an Airbnb as being a close call. He acknowledges a real estate brokerage firm, and he acknowledges an embroidery firm. So that issue was dealt with. The trial court recognized it, but he looked at it in the context of a waiver argument under the CC&Rs, not in the context of a fair housing selective enforcement.
Thank you.
Thank you.
Counsel, we thank you both for your arguments. This matter is now under advisement, and we will issue a written ruling in due course. Thank you. We're at recess.